convenience here. Is there any harm? We say not, my lord. We will finish today. General Khaib is only available from Monday, my lord. We can cross-examine, put it out there. We will definitely finish today. All the relevant issues. We're not going into issues beyond. We're not grabbing the opportunity of getting stuck into Captain Collins on unrelated issues or anything else. It's directly in point, my lord, on objective facts and documents that we have here. And my lord, there are more documents that would come into the cross-examination but the documents that are before this Honourable Court in the application by accused number 13, Mr. Makashula, in his interlocutory, the annexures to his, and then the correspondence attached to his affidavit that was sent to or copied or made available to Captain Collins through the process. Thank you.
Thank you. Gentlemen, the court will now stand down for a while until 11 o'clock, then we will resume again.
If it was applicable. There is reference made to this document, and the court has the papers. In the replying affidavit that my another colleague referred to, that we should have had knowledge of, it is stated by accused number 13 that he obtained this transcript, or rather the information from which the transcript was made, on the 28th of November 2021. It's impossible. By that time, the police hadn't even visited the medic. Then just another aspect. My Lord, with the utmost of respect, if accused number 17, and I've said it throughout this trial, while we were struggling to get her out of America, had she still been in America, for whatever reason, we would have continued with this trial against accused number 13. That's another guarantee that her cooperation or not has no bearing on the prosecution against accused number 13 as we stand today. And again I say, she didn't give a statement. She made certain averments. But there's no statement that we could use as indicated against accused number 30. There is still no basis with the utmost of respect. Thank you.
Lawyer from the side. I want to correct two misstatements by Mr. Donation, and I have no intention of becoming personal on this, but I want to refer your Lordship to the Exhibit 11 that we had before this Honourable Court, my Lord. It was the old RA1, and your Lordship will see on page 3 of that document, Brigadier Gerber does refer to section 2 of so there was reference and it was brought in, and I want to read it to your Lordship because it makes it clear, and it will also, my Lord, clear the other misstatement by Mr. Donation that she had already at that stage made a statement, my Lord, that they did have in their possession and were fully aware of. So at page 3, my Lord, Brigadier Gerber says, so at this stage, if you do at any stage, how could I say, implicate yourself in anything? She says, Brigadier Gerber, we will obviously then, but at this stage there is no reason for us to warn you in terms of any judge's rules or etc. But if you do incriminate yourself, we will stop you and we will give you the proper warning in terms of that. And then we will discuss the matter forward with you, because there is the three options. We can either, if you do implicate yourself, I do not know if you know what a 204 witness is. Mr. Lotcher says, you can explain further, please. Brigadier Gerber, okay, the 204 witness is, if you're involved in anything, you come forward with it, we take a statement in terms of section 204 of the Criminal Procedure Act. He says, He says, which then still allows you to be a witness for the state, bearing in mind that you have to be forthcoming with your part in the process. She says, okay. Then he says, page 4. The court finds your testimony is truthful, they will absolve you from any wrongdoing in the case, but your testimony is important in that aspect, alright. Then he says, my Lord, if we proceed and it becomes apparent that the 204 route will not work, or you're unwilling to go that route with us, obviously we will have to explore other avenues then in terms of maybe viewing you in a different light as a suspect in the matter, which is not at the current stage what you are doing. Ms. Chirota answers, okay. Brigadier Gerber says, alright, so this interview will depend on how you approach us. Ms. Chirota says, Brigadier Gerber says, and what we get from you after the interview. And then it says, okay, she says, okay, so is, he says, okay, so, she says, can I ask a question? He says, yes, you can ask, please. She says, is interview part of being a state witness, or is the follow-up based on? And he says, yeah, it is part of it. Is a follow-up on the statement you submitted at the state. She then says, on the Zonda Commission, he says, yes, she says, then he says, but we from our side as SAPS, as DPCR, we need a statement from you, a comprehensive. So she says, as a what? As a state witness, or as a, he says, as a state witness, yes. She says, so I am the state witness. He says, you're a state witness, yes, at this stage we are viewing you as a state witness. She says, okay, so I've been told now that I am a state witness because ever since I've been seeing everything on media, I have never been approached by anyone. I've never received any letter in some days where I'm asking now that. He intervenes and says, you're not truthful about that because I sent you an email. We know the date of the email, my lord. You sent, she says, after my email, he says, yes. She said, I said I'm aware of what is happening, so I'm the state witness, it is fine. He intervenes and says, yeah, we did not know where to get hold of you there, but so eventually, and she says, but my contacts have always been there, but it is okay, I understand. So it's clear, my lord, and I can take your lordship through, and I can even take you to this witness's statement before the Constitutional Court, which absolutely carries it home, my lord, if I may refer your lordship to it, which is already an exhibit before this honourable court. But the first point I'm making, my lord, is, number one, she was threatened with either being a 204 witness or a suspect. It's clear from the transcript. Over and above that, my lord, it is clear that they were aware of a statement that she had. And then the most crucial aspect of this point, my lord, is in the file that's already before your lordship, that's Exhibit N. It's the tab, my lord, that deals with the Constitutional Court affidavit that was deposed to by Captain Carlett. Paragraph 100 and 33 and 134. He says, the fact that Ms. Charlotte did not attribute certain instructions to a former boss had the result that she was then treated as a suspect in relation to some of the same charges Mr. Makashula, a former boss, was facing. So now we have an issue, my lord. There it is, black on white. The fact that she failed to attribute conduct made her into a suspect. Now that goes against, well, we had evidence against her before we began, which was his evidence in chief. But paragraph 134, he says, I deny that Ms. Charlotte's liberty was ever threatened. She was merely warned that she was, owing to her non-cooperation, considered to be a suspect. The choice to cooperate or not was Ms. Charlotte's to make. There was much evidence to hand that she facilitated payments from alleged service providers in respect of various bursaries and other educational related expenses through the office of the Premier in the Free State. In my view, that evidence was sufficient to treat her as a suspect. So there's that threat, you're a suspect unless you give us the version that we're looking for. And then, my lord, what we have, and it's in the same file, and I'm going to take your lordship through it if I may. We have the exchange of emails, and I had said to your lordship that it was our intention during cross-examination to introduce an email that the state was in possession of that follows on the trail of emails that we have under tab 8R, my lord. Then in 8R, further on, my lord, we have AA7, which is then a letter on the letterhead of the Premier of the Free State Province to Ms. Charlotte. That is dated 16th of August 2022, my lord, which is headed, it's addressed to Ms. Charlotte, possible termination of the bursary. It says, this letter is addressed to you in terms of paragraph 3.3 and 4.15 of the bursary agreement concluded between yourself and the Office of the Premier on 4 February 2020. It came to my attention that a warrant for your arrest has been issued in South Africa and an application for your extradition to South Africa was submitted to the relevant authorities in the United States of America. And then it says there, it will appear as if you failed to provide your cooperation with the law enforcement agencies in South Africa. That is in breach of paragraphs 332 and 334 of the bursary agreement. And you'll see, my lord, that she then invited to make representation by 31 August 2022. And the author of that document, my lord, is Mr. Kopong Radikotani, the Director General, whom this witness admitted under cross-examination he spoke to frequently but never obtained a statement from. The next document, my lord, is AA8, where Ms. Charlotte then makes representations to this very same person, Mr. Radikotani, explaining her position that she had intended to cooperate and how important the studies are to her. And then that's followed, that's, if I can put a date to that, my lord. It's not dated, but at AA9, he responds to her letter, and he says, my letter dated 18 August 2022, as well as your replies dated 18 and 19 August 2022, a reference. Kindly be advised that I've duly considered your representation and I have decided to keep my decisions regarding your bursary in abeyance pending our meeting. You are directed to report to my office within 10 days of the date of this letter to enable us to resolve the impasse with the South African law enforcement authorities. Should you fail to do so, your bursary will be revoked with immediate effect, which I trust will not be necessary. And I trust that you will find it in order and signed off by Mr. Radikotani, 19th of September 2022. And then the final letter, my lord, that then puts us finally to bed and shows exactly what did in fact happen, is it's got a heading here, AA10, my lord, from the Office of the Premier, from the very same Mr. Kopong Radikotani, and it's addressed to Ms. Charlotte on the 6th of October 2022, and it's headed termination of your bursary. Previous correspondence exchanged through emails, especially my letter dated 19 September 2022, and your reply of 21 September 2022 of reference. Your submission does not provide substantial motivation for me to review or reconsider my decision to terminate your bursary with immediate effect. No further payments will be made to support your studies. The Office of the Premier remains responsible to pay for your flight ticket to return to South Africa should you wish to do so. So these, my lord, are the clearest indication of the stratagem that is employed to pressurize Mr. Rota to, in our submission, falsely implicate Mr. Makashula in the commission of these offences that played a role in the state having, in advance of ever receiving a statement from her, my lord, labelling her a state witness. Where the only statement that was in existence at that stage, my lord, wasn't in the docket, it was at the State Capture Commission, and it was totally, it's here before your lordship, I can show it to your lordship, it's totally exculpatory of Mr. Makashula. So it has a direct impact on this inquiry and is influenced by this, my lord. May I just see a note, my lord, before I sit down? Yes. My lord, we say that this would be the correct time to allow the cross-examination because it will have a bearing on the very inquiry that your lordship has to answer to the judgment. We see no harm in the evidence being properly fleeced out at this stage, my lord, as opposed to, as I used the example previously, my lord, of coming up with the transcript of the proceedings at a later stage and the court cannot take it into account. And we don't believe it can cause any harm, my lord, in the administration of justice. In fact, we respectfully submit, my lord, that to refuse cross-examination would be detrimental to these accused and would be a failure and it would result in an unfair trial. It's regarded, my lord, as one of the most powerful tools in securing the truth. And that's, after all, is what this court ought to be seeking at this stage, my lord. Thank you, my lord. Yes.
Mr. Ouders, the court is not yet fully satisfied that your client has any interest that could bear any fruits at this point in this trial, within a trial, and the verdict of the court, whether the court has the jurisdiction to try accused number 17 or not. I'm not satisfied that that is the position, and I'm going to give you a last chance. I'm being honest with you, Mr. Ouders. In order to be fair towards you and your client. Because if I look at it, say for instance, this court decides that the trial must go on against accused number 17. I reject, in other words, the plea of no jurisdiction. How will it impact upon the interests of your client?
With no impertinence intended, and I apologize in advance.
Yes.
It raises certain questions, my lord, if I may, and I'm being absolutely honest with the lordship, and I excuse myself in advance. My lord, the refusal to allow cross-examination results in more questions than answers, and I'll explain myself. There are documents in this file, my lord, that we had never seen and that requested, that were handed to your lordship and we granted like manna from heaven because we'd never seen these documents. These documents gave a different view to what we had formed, and I accept responsibility when we read the correspondence with the state. But more significantly, my lord, what is the evidential value of some of these documents that have never been referred to as yet? They've been handed to your lordship. Your lordship gave an assurance that your lordship agreed with the entire file. And I'll use one example that was the subject of some of the cross-examination. Tab C is it was an unsigned but unstamped replaced affidavit by Advocate the Nation that was handed to your lordship, but nobody's referred to it as yet, my lord. What status does it enjoy? If we go one step further, my lord, the actual index has a column that refers to comments. And that too, my lord, gives us some type of narrative that I'm unaware, nobody's addressed it as yet. But the point that I wish to make, my lord, and I want to urge your lordship to reconsider this interlocutory decision and to allow cross-examination, my lord, is going back to the first point that I made. What if your lordship rules now that the court has jurisdiction because your lordship hasn't heard everything, and through the course of the trial Your Lordship establishes that yes, on cross-examination of Captain Carlitz and or General Gerber, this court should never have allowed this trial to continue. Then there's a problem, my Lord, because if one looks at the Criminal Procedure Act, I'm going on memory, but I'll check my act, my Lord, Section 110, 111, Section 110 says, if the court finds that it doesn't have jurisdiction, it must remand the matter to the court that does in fact have jurisdiction. That's the relief. So you can't, with respect, my Lord, reconsider this at a later stage and come to that ruling. It goes one step further, my Lord, in Section 110 it says, if the accused don't raise jurisdiction as an issue, then they are taken to have accepted the court's jurisdiction. So it becomes a major problem, my Lord, that ought to be resolved up front and finally, not with the hope that nothing else comes out later or that nothing else is raised later that leaves any doubt in the court's mind, because it's not a situation the court can revisit later on. So in my respectful submission, my Lord, and it's not intended as impertinence, this court ought to grab as much information as it can at this stage and be receptive to it with the view to coming to that decision, because it's not an interlocutory decision that one can decide later on, like a confession or admission or a document where the evidential value is an issue, or whether even its admissibility is an issue where the court can reconsider later on. This is a final decision that the records and the process is appealable. So it can bring an end to the proceedings, or it can remain a thorn in the side of the proceedings until they complete it, because you cannot later on
against the
make a decision.
Q17, yes.
I beg your pardon?
As far as the Q17 is concerned, it will be appealable.
Yes, my Lord.
Yeah.
Yes. I'm saying the jurisdiction issue, my Lord. Then that, and I'm saying from a Q17's perspective, Mr. Lotz's perspective, one cannot leave it hanging in abeyance and hope that nothing further comes out that can disturb the finding of the court, well knowing, my Lord, that we have expressed the desire to cross-examine in the interest of justice on the relevant issue, nothing else. Because as your Lordship envisaged, later on, Captain Carlitz could be called to testify, you can reserve your right, and when he does that, you put the version. And then my question, my Lord, to my learned friends and to your Lordship is, what if then your Lordship finds that there is something that's troubling me here in relation to the jurisdiction issue of Mr. Lotto? Should it not be ventilated finally here up front at this stage rather than leaving it over to later? And it's not restricted to me, my Lord. As far as I'm concerned, my submission remains. Anybody who can contribute to the determination of that issue has an obligation as an officer of the court to do so here and now, not later. So in other words, to use the illustration that I've used previously, my Lord, if I'd been sitting with a transcript that went totally against the state's case and didn't raise it at that issue, but later on kept it back because I wanted to cross-examine Captain Carlitz during the trial and show that he's not telling the truth, and I said, look, but you've got a recording, then there'd be a problem, my Lord. That's why I honestly and sincerely, as an officer of the court, believe that in the interest of justice that the cross-examination be allowed. It can only assist, it can't do any harm to this honourable court in the determination of this issue. Thank you, Lord.
Just one last thing, Mr. Otis. I've been listening to you. You've referred to a number of documents, and you've read parts from those documents. I'm only asking, as a last resort, isn't there a possibility that at least you can argue fully on what you have without doing any further cross-examination?
I don't believe so, my Lord. The argument is possible, but it won't be as effective, and I don't believe that the questions will be answered. Let me use a practical example, if I may, my Lord, and to get the precise issue for your Lordships, to make it very clear. And this will be, I believe, I thought that I had convinced your Lordship, but I see that I haven't, but let me be very, very clear. Your Lordship knows, and let's use the document that is here. If one has regard to the warning statement, my Lord, and I've said to your Lordship, in the warning statement, and you've heard the testimony of the captain who's present and listening, and I have no issue with it. In the warning statement, which is under tab HR, legal documents that are here, my Lord. And I believe that this is a perfect example. Lordship will see from that on the third page, at 11:26, Special Agent Dean of the FBI was excused. If one then turns to the request for legal practitioner, that's labeled page 2, paragraph 3. There's a request for a legal practitioner, and then you'll see that there's an undertaking on page 3, paragraph 5, that to personally see to the drawing up of the statement would furnish me with the statement on or before 23 October 2021. And thereafter, it says the suspect was not willing to answer any questions at this stage and will provide the statement as agreed on or before 23 October 2021. And then your Lordship will see at page 5, paragraph 10, the interview was interrupted from 11:15 to 11:25. And the reason was to inquire about legal representation from Colonel Makalani. I could be wrong in the name. So you'll see that at 11:25 they come back and say there's no lawyer available. At 11:26 the FBI excuses herself. And they then end the interview with an undertaking to provide a statement by 23 October. But then, my Lord, if one turns back in this bundle to the very first tab, and I'll get to explain that there's the request, my Lord, by the government of the Republic of South Africa to the government of America. And my Lord, in that request, if one turns to page 9 or 15, and next to the letter F, there's something remarkable, my Lord. The Lordship also said, warrant of arrest in respect of Mr. Piet Pompies. I don't know if Piet Pompies is or could be, but this is the heading that was submitted to the Americans, my Lord. Then it continues. The original warrant of arrest in respect of Ms. Chiloto was issued by the magistrate for the district of Bloemfontein on 7 October 2021, of which a copy is attached to Captain Carter's affidavit as Annexure B2. So what do we get from that, my Lord? And this is something that needs to be clarified in cross-examination. We get what purported to be, and is made up by the state to be, a sincere attempt to interview a witness to get a statement that went haywire, we say, because she failed to incriminate her former boss and co-accused here, and which ended with her being given an opportunity to file a warning statement by the 23rd of October 2021. But how sincere could that have been if on 7 October 2020 this very same witness applied for and obtained a warrant for her arrest, irrespective of whatever version she was going to come up with? And we believe, my Lord, with respect, and I cannot urge your Lordship more, and I cannot emphasize enough how important it is that this ought to be resolved in cross-examination, my Lord, because these questions are going to linger throughout the trial if they're not resolved as soon as possible. That's just one example, my Lord, but it's a very clear example of where we hope to go in the cross-examination, my Lord. And I do believe that this demands answers. May I just engage with my dream, my Lord? My Lord, my junior, Ms. Governor, says, I ought to say, if you've illustrated our bona fides as officers of the court, so we should be considered friends of the court. Is there a possibility of our clients and our co-accused benefiting? Certainly there is, but you make full disclosure. We're transparent about that, my Lord. We don't see it, but then one must ask, my Lord, in the balancing of balance of convenience here, is there any harm? We say not, my Lord. We will finish today. General Khair is only available from Monday, my Lord. We can cross-examine, put it out there. We will definitely finish today. All the relevant issues. We're not going into issues beyond. We're not grabbing the opportunity of getting stuck into Captain Collett on unrelated issues or anything else. It's directly in point, my Lord, on objective facts and documents that we have here. And my Lord, there are more documents that would come into the cross-examination that the documents that are before this Honourable Court in the application by accused number 13, Mr. Makashula, in his interlocutory, the annexures to his, and then the correspondence attached to his affidavit that was sent to or copied or made available to Captain Collins through the process. Thank you.
Thank you. Gentlemen, the court will now stand down for a while until 11 o'clock. Then we will resume again.
Would you agree?
Now, put a name to the wording, yes.
Sorry?
By
Thank you.
put a name to the wording of the emails, my lord.
Any name or
In a name, just a name. If we had a name, we would have been satisfied.
No. You were given names. I can show you in the transcript. You wanted one particular name, Mr. Makashule.
Well, it says Premier, so logic says it would be the Premier.
Captain, I'm not going to let you out of this one. Your own affidavit in the Constitutional Court says that. I'll read it to you if you like.
No,
You
no,
wanted his name. His Lordship's asked you the question. You wanted the name, Mr. Makashule.
Yes, we did.
We'll get there. Thank you.
Yes.
Now, I need to, unfortunately, go back and explain to you what had happened because it came out of the application. Only in relation to this, the Ms. Chilota, Mr. Makashula, and the police and prosecution. You remember there were newspaper articles that featured about this matter that revealed after the 13th of November that she would be a state witness. Do you agree?
I recall something like that, yes.
And we've seen the emails that then followed after those newspaper articles.
Yes, between the advocate and the general. Yes.
And Mr. Nkwashu at the time acting for both Mr. Makashula and Ms. Chilota. You agree with me?
I do.
And those had all been referred to prior to the meeting at the Sheraton Hotel on the 22nd of September 2021. Do you agree with me?
Yes, the correspondence, yes.
But in the end, they culminated in what the accused number 17 referred to as an open letter or statement on the 6th of November 2021. It's in the file, I'll show it to you. It's difficult to find because it doesn't have its own tab. It's in a little tab.
let us take lunch break.
If I may, I was going to propose that my find the pages.
For resume again at 2 o'clock this afternoon. Guys.
I don't know if you guys want it printed. I can send it.
Within a trial concerns accused number 17 only, who pleaded a special plea to the charges against her to the effect that this court does not have the jurisdiction to try her case because her extradition from the USA was tainted by unlawfulness and irregularity. The state witness, now in the witness stand, has already been cross-examined by the advocate appearing for her. Mr. Ouders says that it is in the interest of justice that he also be allowed to cross-examine the witness. He said this in response to the court's question on how his client can have an interest in this court's verdict in the trial within a trial. Earlier in the trial within a trial, the court has allowed a transcript of an interview between two SA police officers and accused 17 in the USA to be handed in as an exhibit. The court did so in order to have all available information before it, in order to come to an informed conclusion in the trial within a trial. If the court now adopts the same approach, the court will allow Mr. Ouders to cross-examine the present witness, but under the strict condition that all questions must be relevant to the question whether this court has jurisdiction to hear and to try the charges against accused number 17. The court will not allow any questions to the present witness which will have a bearing on the merits of the case against accused number 13. The court does not know at this point exactly in which respect Mr. Ouders says that it is in the interest of justice that he cross-examines this witness, but I will take his word for granted as an officer of this court, and I will allow him to cross-examine as I've already indicated, but then on condition that everything he asks this witness must be relevant to the question whether this court has jurisdiction to try accused number 17. Thank you, Mr. Ouders.
Captain, you're still under oath to speak the truth.
Yes, I am.
You may receive it.
Morning, Captain. We've heard from your examination in chief that you have more than 30 years experience in the South African Police Service. You confirm that? During September 2021, the starting point of the problem would be on the 13th of November 2020, you were present in court when it was placed on record that accused number 13 was a state witness. Is that correct?
If I recall the date, yes, sir.
My lord, if I may just assist my learned colleague, it was to be accused number 7 was to be a state witness, not accused number 13. Yes, accused number 13 was to be accused.
Thank you. Number 13 was arrested, Mr. Makashula, and it was placed on record that one of his bail conditions was that he may not communicate with the state witness, Ms. Chilota. You agree?
I agree.
You were present in court and heard that. You agree?
Yes, I do.
At that stage, you had not obtained a statement from her in the docket, other than her statement before the Zondo Commission. Do you agree with me?
I do agree.
Thereafter, there was an exchange of emails where, and I don't want to repeat what other people have repeated, she had requested details of how she became a state witness, and it was responded that she could give vital information. Do you agree with me?
I do.
In response to that, she asked for a copy of the documents on which she was going to be made a state witness. Do you agree with me?
Yes, according to the emails we do.
In fact, let's be specific. Let's go to the document. It's been referred to as AA1, where on the 18th of November 2020, Mr. Lotto sent an email to Advocate the Nation copying you, in which he said, "Good day, sir. I hereby acknowledge your correspondence with appreciation. I thank you for the clarification in this regard. It is loud and clear that I do not have any choice. I can assure you my 100% cooperation in this matter, solely because I respect the law. I will definitely appreciate a copy of the affidavit when you are ready. Going forward, I will hear from you. Best regards," and it's signed off by Mr. Lotto. Do you confirm that email? Would you like to see it?
I confirm.
All right. So it was, no, hang on to your lordship. So it was clear that she had responded saying that she had no choice in the matter. Do you agree with me?
That is what the mail says. Yes.
At that stage, you and Advocate the Nation knew that she had been represented by Mr. Nkwashu. Do you confirm?
No, I would confirm, yes.
And that you'd been to the Zondo Commission with Mr. Nkwashu. It was on public TV and everything. Do you agree?
I haven't looked at everything, but I'll take your word for that.
So here she asked for a copy of the affidavit when the state is ready. Do you confirm that?
Yes, I do.
Well, you've testified that no such copy was ever provided to her. Do you agree?
I do.
Now, from the 18th of November 2020, the next step, as we understand it, is the interview that took place on the 22nd of September 2021. Do you agree?
I do.
In that intervening period, from November 2020 to September 2021, did you or anybody from your office or from the prosecution provide with a copy of any of the documents that were referred to in the emails?
To her, if I may ask.
Yeah. Yes.
Not that I'm aware of.
Well, speaking for yourself, you didn't.
No, I did.
Now, in order to go to America to interview her, there's a process that you have to follow in South Africa to make application to travel and to secure the funds and permission to do so. Do you agree?
Yes, I do.
When you did that application, what did you put as your motivation for the proposed trip to America?
Me, myself, didn't do the motivation. That was done by the NPA's office, and then corresponded with our head office. So from my side, I basically just got the instruction. Everything has been arranged, and I'm ready to go.
When you got the instruction, everything has been arranged, you mean the travel arrangements and flight permission, etc. Do you agree with me?
That's good.
You never contacted Mr. Lott and said, "You're coming through on the 22nd of November. Can you tell us what time will suit you and can we get together?" You agree with me?
I do agree.
Instead, you remained silent and arrived there without any prior notification to her. Do you agree with me?
From my side, yes.
Why did you do that?
I can't say there's a specific reason, but all the correspondence directly with her was done by my senior official, General Gerber, and Advocate Denise. Me myself wasn't, I can put it, it wasn't allocated to me to correspond, if I can put it bluntly like that.
In your evidence in chief, you said during September 2021 you embarked on a trip to the USA after Advocate the Nation and you had discussed and decided to have an interview with Ms. Chilota to get clarity on certain issues. Do you remember that?
Yes, I do.
So you weren't as uninvolved as you want to create the impression of right now. You knew why you were going, and it was after this discussion with Advocate Donation to get clarity from Ms. Chilota. Do you agree with me?
I wouldn't say, that if you talk about the uninvolvement, obviously there's discussions between me and my prosecutor, that I do agree with. That's part of the investigation. But the physical arrangements, I was not part of.
And you further testified in chief that prior to going to the USA, there was evidence that implicated Ms. Chilota. Do you remember that?
I do.
So you knew at that stage that you had evidence that implicated her, and that's borne out by the warning that General Gerber gave her at the commencement of the meeting. Do you agree with me?
I do.
So at that stage, it's logical that you could either have been a suspect or a Section 204 witness or a straightforward state witness, but you can exclude the third because there's evidence that you said implicated her. Do you agree with me?
No, I do not agree with that.
Well, let me ask you differently then. If you're in possession of information or evidence that implicated her, I put to you that the only way that you could make her a state witness would be in terms of Section 204 of the Criminal Procedure Act. Do you have any comments?
No, that will be correct.
So you had this evidence that implicated her that you could use as a means to threaten her into doing things and giving a version. Do you agree with me?
No, I do not.
Well, what was the purpose then?
To get clarity on aspects. As I said, the information we had was there that implicated itself as we saw it. But by getting an explanation from her, that could exonerate. That was the purpose, to get explanations on what we have on hand.
The only way that she could exonerate herself would be if she implicated accused number 13 and said that she had done so on his instructions. Do you agree with me?
Well, if you put it to say we went specifically after accused 13, I can't say that is the truth. We wanted clarity on the wording in the emails.
And what you said in your... Sorry, I didn't mean to cut.
No.
What you said in your evidence in chief is that you had communications between Ms. Chilota and contractors requesting money for students made by her on instructions of the Premier as indicated in her emails. Is that correct?
That's correct.
So now it's clear we've reached the stage where you required her to implicate the Premier. Do you agree with me?
If you put it like that, yes.
I do. I put it exactly like that.
Then it is like that.
So we've now established that she was implicated herself, that she had the potential to become a Section 204 witness if she implicated Mr. Magashule. Do you agree?
Well, if she implicated Mr. Magashule, I don't think that will be a 204. That will be explanation on the questions that we asked.
Because then she'd be exonerated.
Well, then she would give a reasonable explanation, yes.
And she'd be exonerated. She'd say, I did this on instructions of my boss at the time.
Yes, basically, yes.
So that was the purpose of those interviews. And I can show it to you in your own email, in your own affidavit. You make it clear that that was the purpose. Do you agree with me?
Yeah, we wanted clarity, yes.
Right. And the clarity was the implication of her boss, the Premier. Do you agree?
Yes.
Right. When that didn't work, the negotiations or interviews came to an end. They ceased. Do you agree with me?
Yeah, it became to a standstill, yes.
Now, we need to contextualize this out of fairness to both sides. And it works as follows. You knew Mr. Nkwashu acted for Mr. Magashule and Ms. Chilota. Do you agree with me?
Yes.
Right. You then, through the offices or through the emails, let's be more specific, of Advocate Donation and General Carlett, made it clear that she may not communicate with Mr. Nkwashu. Do you agree with me, the attorney? Let's say I can show it to you.
No. I agree. You just said Are we talking about myself or General Gerber?
The emails make it clear. I'm not attributing it to you. I said the emails from Gerber and the Nation make it clear that she may not communicate with her erstwhile attorney, Mr. Nkwashu.
Yes, I agree.
So in effect, you, prior to the 22nd of September 2021, told her she may not communicate with her attorney, and then set up a meeting with her without any arrangements by you, and never said to her, well, have a new attorney if you want in the meeting. Do you agree with me?
No, well, not on my side.
You agree?
Yes.
So then you have a meeting, and you've told this court that in that meeting you had invited her to obtain legal representation. Do you remember that?
No, that was the end of the first day, yes.
That doesn't appear anywhere from the transcript. Do you agree with me?
That is also, yes, I saw that.
Now, the creation of that transcript can be attributed to a number of people. It could be attributed to yourself and General Gerber, or Ms. Chilotta, or the FBI. Do you agree?
Well, it could be anyone, yes.
Now, you've told this court that you and the General, two experienced high-ranked officers, went into that meeting on 22nd of September with the view to recording the conversation. Do you agree with me?
I do.
As I understand what was placed on record by Advocate the Nation, that's not your recording, and your testimony was that the recorder didn't work. Is that correct?
That is correct.
So the logical conclusion is that here we have two highly respected police officers going to a meeting in America, intending to record it, and out comes the student who has no training or anything with the recording. Is the only inference if yours wasn't the one that we have. Do you agree with me?
Can you just repeat?
Yes.
I didn't understand. Please?
The two of you, you and the General at that time, Brigadier, intended to record the meeting.
We did, yes.
You put a recorder, or he, I beg your pardon, put a recorder, put him on the table and said, I'm recording this conversation, and he gave a reason for it. He says there, I'm going to read it to you. He says there are no misperceptions of what we are saying and what we are doing.
Yes.
That recording, as you say, never worked.
No, we did not.
The logical conclusion would be that if that didn't work, and this isn't what was recorded on that machine, this could have been recorded by Ms. Chilotta on her cell phone or something.
That is the assumption we're making. Yes.
You then went one step further and said, well, there are things missing, there are omissions here. She could have cut certain portions. So is it your evidence that during this meeting she had a cell phone and she could control that which she recorded or didn't record in that meeting?
Well, most probably. I do not say everything. As I mentioned in my testimony, what looked for me suspicious, or not suspicious, is the fact that when we had a break, as it indicated in the transcripts, when she went and saw her boyfriend. There's nothing like that. And even, no, it's mentioned there, but it shows it was switched off because there's no discussion. It's not an ongoing discussion where she was. As well as the fact that the advice we gave her, as yourself mentioned, is not on the transcripts. And I wouldn't have made something known to that I've gave her advice, and then it's not on the transcripts. I don't understand why it's not there.
So you draw the inference from that she was the person responsible for this recording.
Currently, it's my thought, yes.
Because you see in the transcript where it says that there's a voice of another man, she steps outside of some sort and then it continues, but that's not recorded.
That's correct.
Okay. So the answer is yes. Despite these two highly ranked police officers who intended to record, in your view, the person who recorded and is responsible for this transcript is Ms. Chilotta, the student.
Currently at this stage, yes.
Now in that meeting, did you not notice that she was in possession of and utilizing the cell phone to do so?
To be honest, I cannot recall.
I'll take it. Now I want to go to that meeting. Everything seems very cordial in your exchange. Do you agree with me? There isn't an instance, and I've given you an opportunity to read this, where you can highlight one question that you asked that you absolutely refused to answer. Do you agree with me? On that day, the 22nd.
Well, yes. If you put it to say she didn't answer anything, she did answer everything.
And it ended off cordially with an arrangement to meet the next day in Washington, D.C., with a view to going to the embassy. Do you agree?
At the morning of the second day.
You had arranged to meet at a
At
station
Washington, yes.
in Washington. There's no mention there of having to arrange with an attorney to be present. Do you agree with me? Or a legal representative of any state?
When we picked her up,
No, when you ended off the first day.
no, we only gave her advice to maybe speak to a legal representative the evening.
But I understood your earlier testimony. So you're saying the advice or suggestion to employ a legal representative was only done after this meeting on the evening before the 23rd?
The first day's meeting, yes.
So you'll agree that it's logical then that
Sorry,
there's
Mr. Otis, I couldn't hear what you were saying.
Excuse me, my lord.
You said, was it at the end of the first day?
The first day.
You referred to legal representation for her.
My lord, we advised her that she should get in contact with a legal representative.
Yes, but I mean, the point is that was at the end of the first day, after the first day's interview.
That's correct.
Thank you. Thank you, Mr. Otis.
And the boyfriend stepping out, just for record purposes, at page 35, at the foot of the page. What you said, before we continue the questions, I want to find out, we've got a gentleman outside. Okay, sorry for that, let us continue. So that's where the boyfriend arrived, it would seem, is that correct?
Yes, it seems so.
And there's no recording that followed her of her meeting with the boyfriend, from which you infer that she must have switched off the machine for that, or the phone, or whatever it might have been, for the meeting with the boyfriend, is that correct?
That is correct.
Right. When she then returned, the questioning became some more relevant, and I'm going to take you, if I may, to the transcript. At page 64, where you say to her, you asked her about various people. Oh, sorry, I thought you had it.
Sorry, I thought that would fail. I do have this. Sorry, actually. I apologize.
It's Exhibit 11 for the page 64. You're on the issue of emails and just giving you all the different people that the emails would go to. If you want to just contextualize it from 62 onwards, you'll see the issue of emails. And at 64, the foot of the page, you say, are you aware of, okay, you are aware of the emails that you sent on behalf of the Premier? Good.
I see that, yes.
She asks you to who?
Okay.
65, you say for different companies, contractors, for donations. She says for the to business people, you say yeah. She then says for school funds, you say yeah, stuff like that. She says yes, I am aware. Then you ask her, you go off that topic and you say to her, now, were there any SARS certificates issued to those companies for tax purposes? How did you expect her to answer that question?
Well, I wouldn't know if she didn't answer. If she said she doesn't know, then I left it there.
Would you then say to, she says, you then say, I think it is a Section 18 certificate. I beg your pardon, says, I think it's a Section 18 certificate. You say, yeah, I think it's a Section 18, and she says, I do not recall by whom, by the government or by who. Then you explain to her that for donations one would be entitled to a tax, it would have tax implications. Do you agree with me?
I do.
If you turn the page, you say to her, no, can I just re-explain to you if I may? She says, You say to her, you sent these emails on instruction of Mr. Makashula. She corrects you. She says, the office of the Premier. You accept that. You say, office of the Premier. She says, yes. So at that stage, the debate was what you referred to in your evidence in chief, where you were trying to pinpoint it to Mr. Makashula, and she was saying to you, it wasn't him, it was the office of the Premier. Do you agree with me?
Yes, she was keep on saying office of the Premier. Yes.
And then you said to her, but obviously if you say the office of the Premier, you have to be specific now. And Brigadier Gerber says, there should be a person. You say, yeah. Then Brigadier Gerber says, the office cannot, and she says, the office of the Premier would be us. When you're assisting people who come to the office of the Premier, to me it is the office of the Premier who is assisting them, right? Then you say, okay, but you must remember we cannot talk to as an organization. The Premier's office is, we have to put it to a person, you understand? She says, okay. Then you say to her, so when you send these emails, these mails saying in the mails on request of the Premier, you're requesting a donation, say, for studies for this and this person. She says, okay, then, and there's intervening and indistinction, and then she says, then you continue. Do you mean the Premier told you to write an email to businesses saying, listen, I'm asking for donations for this and this student at this and this university? And she says, okay, that is not how I did it. So she's telling you what you did in fact do. Do you agree?
Well, she just said this is not how she did it. She didn't go and explain further, if I'm correct.
And then she says in line 10, what I did was request from the office of the Premier, because the people who would ask help would come to the office of the Premier. So me handing it, I was handing it as the office of the Premier. I was not saying specifically the Premier said you must help this person, because even when I asked, it was a request, not a directive, that you must help these people. Do you agree?
This is what it says, huh?
So she's telling you, you can't attribute it to Mr. Makashula, you can attribute it to the office of the Premier. Do you agree? That was her version too, it's black on white.
Yes, no, I agree.
And she goes further and she explains, I would ask if is it possible that you can assist us with this kind of student and so forth? You say, so you're basically telling me you asked own initiative, you used own initiative to see who is in need and then request assistance. She says, all of them, not my own initiative. We would have different students who are coming to the office, we would draft. Now, what he's trying to say is, remember earlier on we asked you, did you take executive decision? And you said no. He says, Then Gerber says, now someone coming to the office and requesting a bursary or whatever, she says, You say, no, there's an executive decision for you to approach a company to say, please, you donate, even if it is on the office of the Premier. She says, You say, money for a student. She says, Then you say, did you? Or are you saying that you took those decisions by yourself to approach those companies and ask them for money? And she says, because Then you say to her, not informing the Premier. And she says, no, the Premier would know, and Miss Janet Kay would know, but it was the procedure of financial assistance that has been going on in the office of the Premier. The Premier would not, the Premier, even if he speaks, he would say, no, if the bursaries are finished, we must do something to help the students. You understand, it was not to be a directive to say, go and ask this person about this. It was the nature of the indistinct, knowing that even if the government cannot help to this extent, then we would go out and request financial assistance for these students. Brigadier Gerber says, on whose instruction? And she says, from the office of the Premier, am I not understanding your question? And now we start the debate all over again. But what I want to put to you, and I'm not going into the merits, it's only on this issue. You and Brigadier Gerber were looking for the answer on the instructions of Mr. Makashule. Do you agree with me?
That is what the emails implicated, and that is what we wanted. Yes.
Thank you. Right. That's how you read the emails, and that's what you wanted. Do you agree?
Yes.
Right. Because it continues. Brigadier Gerber says, the office cannot give you an instruction. You say there is too many people working at the office of the Premier. She says, correct. You say, okay, but who gave this instruction? Not the office of the Premier. There is 20, 50 people working. Gerber adds, there is Janet Kay, there is whoever is in the office. We are asking who gave the instruction. A simple question. She says, I'm saying yes, and I'm trying to explain it that it has there's been an ongoing thing in the office that whenever we do not have funds, we go and outsource for them. And it continues. Brigadier Gerber says, now I understand, but you say we. Who is the we? And you said specifically earlier you do not have executive powers. She says yes. Captain Collins then says, so me in my office, let us take my office for instance, you will not go and approach someone to do something on behalf of the office. It is not okayed by me. She says, of course. You say, now in your office, in the Premier's office, she says, the Premier would know that we are outsourcing for students. And you say, okay. She says, yes. You say, so he would be aware of, and she says, he would be aware of. You say, okay, and same with her. And then you say, would he indicate to you who to approach? So maybe look at this businessman or look at that one, or, and she says, I doubt, because I would be the one sending requests to different business people. And you'd say, and how would you know now? And she says, and then remember, the last time I was explained, they also got a list from the database. Also got a list from the laptop, the very same laptop that Miss Maria was using. That is why I'm saying it is an ongoing thing that I found there happening. Also on my own, I would just find out the simple thing that I used was indistinct foundation. If I hear that there is an indistinct foundation who is assisting the students, I'll also find their contact number and ask. We also have students who are asking for this. Would you be able to help? So I did not have any specific people that I had to contact if I'm making it clear. Then you say, yeah, no. She says there was, and you say, yeah, no, I understand. So in general, the process that is followed at the office of the Premier employees, she says, all right, you say, is to ask for assistance from business people. She says, correct. And then you ask her, but the general instruction to do this was given by the Premier. She says, I do not know if it is. You intervene, but when you came there, that was the norm. She says, yes, it was. And obviously, you say, and she says, at the office of the Premier is always. And you say, obviously, someone told you this is the way we do it, because otherwise, you took that decision on your own. She says, not the decision that I took on my own. So what I want to put to you is you are saying to her, either you take responsibility for the decision, or you allocate it to Mr. Makashuli. Do you agree with me?
Yes, I do.
And she was saying to you, no, I can't attribute it directly to him. There's several people working in that office that she refused to be pinned down on the Premier or Mr. Makashule personally. Do you agree?
Do you mean by possibly implicating someone else rather than the Premier?
That she refused to implicate the Premier or Mr. Makashule to identify him. Do you agree with me?
Yes.
And that's what led you that night, or after that meeting, to engage with Advocate Donation and say, listen, this woman's not cooperating. We need to possibly warn her, make her a suspect, or make her a tour for whatever you discussed with him. Do you agree with me?
That was part of the discussion myself.
Now we know the second meeting took place, 23rd of September at the embassy. There were no recording machines allowed by anybody. Do you agree with me? So there's no recording of that meeting. But what we know is that at some stage, and you know the time, you completed a warning statement for her. Is that correct?
That's correct.
So you had a copy of a warning statement, but you didn't ever provide a copy of her own statement or the requested documents to her. Do you agree with me?
The statement from the Commission?
Yes.
Yes.
Any reason why that's the case? That this woman's asked you, please bring the documents, please send the documents. You can get from the transcript, she hadn't bathed, she hadn't gotten ready.
As I explained on my testimony during the week, it would happen, not to say in this instance in general, that if a person provides an affidavit or an explanation, it's not to say that we will provide that affidavit during questioning to confirm whether the facts given during the first or another interview corresponds with what we are asking.
Now, can you just give us the times that events took place on the 22nd of September? I'm talking about the first day. At what time did you meet with the FBI with the purpose of going to her home address?
Yeah, if I recall correctly, it was around about 7:30, 8 o'clock.
And then, what time did you get to her house?
Just past 8, 8:15, somewhere there.
And then how long did it take them to bring her out of there to attend the interview?
15, 20 minutes maybe.
So we can infer from that she was cooperative. Here's a woman, she wakes up, there's the FBI at the door, no prior notification, she's dressed and out within 15 minutes.
Well, I don't know whether she was dressed. I didn't see her before.
When you say you don't know when she was dressed, you mean when she came out the door when she was in the house?
No, the FBI approached the house. I only saw her when she came out.
She came out dressed?
Yes.
So you knew she was dressed?
Yeah, but I don't know beforehand.
No, but she says it on the recording.
I
I
understand.
haven't had a chance to bath or anything.
Yes.
In
I
15 minutes, you don't expect that she not going to wait while she bathed or anything like that. She came out and cooperated.
I agree.
Did you ever say to her, sorry for not telling you that we're coming or making an arrangement with you? Can you now set your day aside or anything like that?
Not myself at the residence. It could be that it was discussed when we arrived at the hotel.
So I want to put to you, and I'm going to give you every chance to qualify this, that was a compulsory interrogation, do you agree with me?
For that specific days.
Yes.
No, we set out 3 days for the interview.
She was compelled to attend, do you agree with me?
Well, yes, in a sense, but if she have said sorry doesn't suit her, we would have accommodated like we did.
Captain, you arrived there 20 seconds and we're having an interview today. The FBI went in and ensured that she came out escorted by the FBI with a view, even driving her own car, to attending a compulsory interrogation. Do you agree with me?
I do, but as I said, I do not know what was the discussion between the FBI and herself. I do not know what they told her. I do not know if they forced her. I do not know. The thing is, when she came out, it was for me voluntarily.
Let's ask the question in the reverse order, okay? Is there any reason why you never made any arrangements with a former attorney to interview her? Did you find Mr. Nkwashi and say, listen, we're deciding to make this lady a state witness. We're going to be seeing her. Please don't have any communications with her.
Not from my side, no.
Is there any reason why you never contacted her and said, listen, I'm coming through on the following, I'm thinking of traveling on the following days. Please tell me what suits you and we can arrange to meet.
Not from my side, no.
But why not?
As I explained, I did not do the communication with her.
Yeah, but nobody did. It's not like you're saying somebody else could have done it or should have done it. I'm not finished. You planned a trip overseas. You got budgetary allowance. You went all the way to America. Everything was sorted out. But not once did you bother to say, well, let's make sure she's there. What if she goes on holiday? Or what if she's not available? What if she's having an operation? What if she's in class? I mean, it's just normal human behavior to find out if a person's available.
I agree with that.
So why didn't you yourself ensure that she's available, or ensure through other people, the FBI, anybody else, to make an arrangement? Please, Mr. Lotter, be available for a meeting.
All I can say is the communication was said to be done by General Gerber and the African Nation.
I don't use his term of throwing them under the bus. I'm not going there. Okay.
No, I'm not. That is how it is. That is how it is. Although I was CC'd into the emails, that was the decision that was made. And if it comes to me now to say, why didn't I do it? It was a decision that the communication will be done by them.
I find it totally unacceptable, and I'm going to put it, if I'm going to dinner tonight, I'll even ask my junior, the attorney, the restaurant, I'll make an arrangement. I don't just arrive, because anything can happen. The restaurant can be closed, they can be unavailable. You were unaware of any arrangements that have been made with her. Do you agree with me?
Yes.
It's logical, there was no arrangement made with her.
Yes.
Yet you never asked them, have you guys sorted this out? Is she expecting us? Where are we meeting her? Or anything to that effect? You just ride along as a passive observer to see what's going to happen. Is that your evidence?
I cannot answer that in any sense. There's so many discussions that took place. As you say, the normal person. Most probably I did ask that the arrangements were made. Most probably. I do not say it happened. Most probably. Okay, there's no evidence to say it. But in the other instance as well as, I do not know what the FBI did on their side before we arrived. Did they make sure she's at home? That I do not know as well.
No, I'm going to put to you as a fact. Your intention is to catch her by surprise and intimidate her. It's so obvious, it stands out. There's no other logical explanation, sir.
If I can answer like that, yes. It is your opinion.
No, it is. I'm putting it to you as my opinion, but there's not. I'm saying to you, my opinion also is that there's no other logical explanation for this type of conduct.
I do not.
You don't accept it.
No, I do not.
Now let's go one step further. You were here when I addressed the court, okay? On the 23rd, when you had your meeting, you left on the basis that you would have 1 month within which to provide you with a warning statement, having consulted with a legal representative. Do you agree with me?
I do.
You've heard and you're in court that prior to the expiration of that date, you applied for and secured a warrant for arrest.
I must look at the dates.
I'll give you the dates.
Yes.
You can be rest assured.
Yes.
You're attached to your affidavit, and you'll find it in the Exhibit 11 under the A tab.
Sorry, mine isn't referenced like that. May I ask?
Oh, sorry. Being handed to you. If you'll turn in tab A to page 9 of 15, and just familiarize yourself with the document. It's your affidavit in support. I think it's your affidavit.
No, it's not.
It's not your. It's an affidavit by Navilla Somaru, the Director of Public Prosecutions, in support of the request for extradition. And if you turn then to page 9 of 15, you see a heading. See a heading there? Warrant of arrest in respect of Mr. Pete Pompey.
Yeah, I see that.
Where's Pete Pompey?
I don't know if it's a typing mistake. I do not know.
There's no Pete Pompey involved in this matter.
No, there is not.
Okay, and this was the official request to the Americans. It says the original warrant of arrest in respect of Mr. Lotto was issued by the magistrate for the District of Bloemfontein on 7 October 2021, of which a copy is attached to Captain Collins's affidavit as Annexure B2. You see that?
Yes, I do.
Now you had a meeting with her. Now I can show you the warning statement. 23 September 2021. You and General Gerber gave her until the 23rd of October 2021 to provide a written warning statement, having consulted with her legal representative. You agree?
I do. Can I just rectify one thing?
Yes.
That date is determined by us. We ask the person with whom the interview is held what date will suit that person.
Yes.
No, I just want to clarify.
I'm indebted to you. Thank you. It's very, very kind of you, because we'll see how significant it was. So you asked her, by when will you be in a position to consult an attorney in America or legal representative and provide us with a warning statement? And she chose 23 October 2021. Do you agree? And you agreed to that, is that good?
Yes.
You said, no, that's fine, that's reasonable, 1 month. And you recorded it as an undertaking in the warning statement that she had then undertaken to provide a warning statement in writing by 23 October 2021. You agree with me?
I do.
Right. On what basis then, prior to that date, did you go and apply for a warrant for arrest?
Well, the warrant was asked for afterwards.
Yeah.
The due date is 23 September. We asked 7
Now,
October.
you're in the meeting 23 September.
No, yes. No, can I just have a look at the
Captain,
No, can I just have a look
please, I don't want to
No.
try to catch you up.
No,
Look at the warrant, look at
No, I just want to rectify.
look at your warning statement.
Please, if I may.
Please.
No, sorry, I hear what you say. Yeah, I see the due date for the affidavit is the 23rd of October.
Yes.
And we did the warrant on the 7th.
Yes.
I apologize, yes, you are correct.
That will be stated now. On what basis did you do that?
Well, that would have been on instruction.
Again, from the advocate and the general.
Not the general, my prosecutor.
The advocate donation.
Yes.
Okay, so now let's just put this into bona fides and doing everything correctly, okay? You sat with the student on the 23rd of September. She said to you, I want a legal representative. You took 15 minutes to find one, it wasn't available. You then terminated the meeting on a clear and unequivocal understanding that she would have 1 month within which to provide a warning statement because of her right to a legal representative before she does so. You agree? Yet somehow you come back to South Africa and you get an instruction and you apply for a warrant long before the expiration of that time period. Do you agree with me?
According to this, yes.
Well, there's got nothing else to go by.
No, yeah, I agree.
So let's just work it out. Okay, you were there on the 23rd of September in the meeting. You give her 1 month, but within 2 weeks you apply for a warrant. Do you agree?
I do.
At the time that you applied for a warrant, she still had more than 2 weeks to provide you a warning statement. Do you agree with me?
I do.
Did you mention that at all to the magistrate to whom you applied for a warrant? Did you say, I was in America, I asked her for a warning statement, she insisted on an attorney, so I said to her, you've got till the 23rd of October, but here I am before you applying for a warrant.
I cannot recall whether I did.
I guarantee you didn't tell that.
I take your word for that.
Because the magistrate would have said to you, if he or she applied them on, if you've given the person till the 23rd, let's wait till then. It's logical, do you agree with me?
I do.
So why did you behave like this?
As you said, gone through anyone under the bus, but it was on instruction.
Or on whose instruction?
African answer.
So what we must infer from this is that where you previously highlighted and told all the different courts, Free State and the Constitutional Court, that this woman undertook to provide a warning statement by the 23rd of October, it didn't have really any bearing on you because you were going ahead with a warrant anyway.
On instructions.
On instructions. Let me put it like this. You were instructed to go against the time period that you'd given her and you accepted that and proceeded. You agree?
Yes.
And this was a woman whom you thought could exculpate herself and become a state witness, not even a Section 204 witness, on your testimony today. Do you agree with me?
Yes, I do.
Provided she did one thing, she implicated her boss, Mr. Makashule. Do you agree?
Put a name to the wording, yes.
So
Put your name to?
Put a name to the wording of the emails.
Any name or specifically?
Just a name. If you had a name, we would have been satisfied.
No. You were given names. I can show you in the transcript. You wanted one particular name, Mr. Makashule.
Well, it says Premier, so logic says it would be the Premier.
Captain, I'm not going to let you out of this one. Your own affidavit in the Constitutional Court says that. I'll read it to you if you like.
No.
You wanted his name. His Lordship's asked you the question. You wanted the name, Mr. Makashule.
Yes, we did.
We'll get there. Thank you.
Yes.
Now, I need to, unfortunately, go back and explain to you what had happened because it came out of the application. Only in relation to this, the Ms. Chilota, Mr. Makashule, and the police and prosecution. You remember there were newspaper articles that featured about this matter that revealed after the 13th of November that she would be a state witness. Do you agree?
I recall something like that, yes.
And we've seen the emails that then followed after those newspaper articles.
Yes, between the advocate and the general. Yes.
And Mr. Nkwashu at the time acting for both Mr. Makashule and Ms. Chilota. You agree with me?
I do.
And those had all been referred to prior to the meeting at the Sheraton Hotel on the 22nd of September 2021. Do you agree with me?
Yes, the correspondence, yes.
But in the end, they culminated in what the accused number 17 referred to as an open letter or statement on the 6th of November 2021. It's in the file, I'll show it to you. difficult to find because it doesn't have its own tab, but it's in one of the tabs.
Mr. Harris, let us take the lunch break until
If I may,
2
I was
o'clock.
going to propose that now we're going to find the pages and the
Yes, court will resume again at 2 o'clock. Court judge, yeah?
Can you get a statement printed?
Which one? The open, that city press. We attached it in one of our application.
Me
Never attached it. Isn't it an application? We did and became Concord.
Okay. Then it's good.
By toilet?
Yeah.
Okay.
would incriminate me. You see, the intimidation versus incrimination that I put you from the meeting and the introduction in reference to section 204 in the transcript. Do you agree with me?
Yes.
36. She says, sure enough, when I stuck to my guns would only answer questions related to my Zonda Commission testimony, they gave up and indicated that I left them no choice but to treat you as a suspect. And you'll confirm that's when the warning statement was taken. That's a statement taken of a suspect. Then she regarded that as effectively a charge sheet, she says in 37. And then she says in 38, my legal representatives have informed me that not only is this not legally permissible, as an investigator must reasonably believe that there are grounds to arrest and or to charge someone. If in fact I was being a recalcitrant or uncooperative witness, as they've suggested in the court of law, and it was open for them under the Criminal Procedure Act to either serve me with a subpoena, section 180, have me subpoenaed by the court, section 186, or any of the remedies for a recalcitrant witness under 189.1. So she's saying, due to the fact that she wasn't prepared to give the answers that were requested of her, she was charged, is what she's saying there. And she said she should have rather have been charged as a recalcitrant witness. Do you have any comment?
No, I don't. It's procedure. No, I don't.
39, she says, their decision to intimidate, threaten, and promptly charge me without reason or grounds to is the most blatantly egregious contravention of my constitutional and other rights, both as a witness and as a citizen of South Africa. Do you have any comment to that?
Well, at that stage, she hasn't been charged yet.
She was informed as per the warning statement she's a suspect.
She's a suspect. The final decision lies with the prosecutor.
Once the prosecutors had regard to her warning statement and the contents of the docket, you agree with me?
That's correct.
40. They effectively detained me within the halls of the South African Embassy and institutional building. They're supposed to be there for the protection of the rights of South Africans. Do you have any comments?
That's not true.
And she says in 41, nothing about any of this conduct and behavior has been ethical. Worse, that they then lie in a court of law informed that I was not cooperating with officials and was therefore charged. So she says that you misled the court and you said that she hadn't been cooperative. Do you have any comments?
No, I didn't.
And she says in 42 that her legal representatives have informed her that is certainly not any ground in law to unlawfully arrest someone and charge them with corruption, money laundering and fraud. Now, ordinarily that would be the case. If somebody is not prepared to give you the answers, you don't lay those charges at the door. You can charge them with perjury if they've lied, etc. Do you agree?
I agree.
And then she expresses a desire that this be shown to various officials. Now, where this becomes important in relation to the reason why I asked to cross-examine you is I want to take you back to correspondence predating the arrest of Mr. Makashura that then impacts on this jurisdictional question, and I'll try to cut through it as quickly to get directly to the point. In order to do so, I'm going to omit the first letters, but they are available. But if you want to refer back, you're more than welcome to. I have copies for you. You'll see it's a correspondence from October 2020. But the important, as far as I'm concerned, starting point would be a letter, and I've made copies for His Lordship, yourself, and the State, dated 25 October 2020. Just to assist you, this letter is sent prior to the arrest and bail application of Mr. Makashura. Do you understand it? It's a letter from my instructing attorney, Mr. Victor Nkwashu, from Victor Nkwashu Attorneys Inc., on 25 October 2020, with the heading, and it's addressed to the DPCR, to General Labia, and to the prosecuting authorities, and it refers to, and it's important that I'll show you this, bring our clients, Mr. Elias Sekobela Makashule and Ms. Muraodi Chulota, it's accused 13 and 16 respectively. And it says, and that's why I told you, if you want the earlier letters, I'll make them available to you, but I didn't want to go beyond the jurisdictional issue with Ms. Chulota. Paragraph 1, your letter dated 22 October 2020, and our previous letters dated 7 October 2020 and 17 October 2020 refer. At the outset, we record that your letter ex facie only responds to our letter of 7 October, not our letter of 17 October. 3. While we appreciate your response as regards our client, Mr. Makashule, we respectfully request you to urgently respond to our letter of 17 October 20 as regards our other client, Ms. Chulota. So I especially left out those earlier letters because I don't want to go beyond the realm of what I am to tell you it related to the leaked information that Mr. Makashule was going to be arrested and requesting confirmation of it. But we're not going to deal with that in this ring-fenced trial. We're going to deal with Ms. Chulota. And here you'll see. It says, as conveyed to, and I'm in paragraph 4, as conveyed to in our 17 October 2020 letter regarding Ms. Chulota, we would appreciate that our client is a citizen of the Republic studying in a foreign country. Now that's correct as far as you know. At that time she was a student studying in America, you agree?
I agree.
Right. And it's clear from this letter that Ms. Chulota is a client of this firm of attorneys, do you agree? It's in the heading and it refers to as our client. 5. In consequence, therefore, our client is particularly apprehensive to be visited by law enforcement authorities of that country, purportedly or ostensibly on your instructions or request. So what had happened, and just as you confirmed it, by virtue of the MLA, Mutual Legal Assistance, Ms. Chulota had been visited by the FBI in America, as at October 2020 already. You confirm it, and you're aware of it?
Oh, yes.
Thank you. 6. In the premises, we strongly urge you to confirm whether this is in fact true, and if not, on what basis the FBI, Federal Bureau of Investigations, would contact our client in respect of matters being investigated in South Africa, currently being investigated by your office. Now, you confirmed that you were aware that the FBI had been to see Ms. Chulota at the request of the South African investigative and prosecutorial authorities. You agree?
Can I just
Please
mention one thing? I cannot recall that they actually interviewed her. I know we asked them to confirm the address, but I cannot confirm whether they interviewed her during that period.
Well, it's important that you tell us that you are aware that in October 2020 there was a request through MLA, Mutual Legal Assistance, to the FBI to confirm Ms. Chulota's address. And it was confirmed.
Yes.
Paragraph 7. Respectfully, the inference is inescapable that the visit by the FBI was at your request and or at the request of someone under your authority. It is inconceivable that a foreign law enforcement agency would be investigating a domestic matter falling within the remit of your office. So it's clear. Well, all they're saying is the visit by the FBI, and you say to verify.
I did.
Notwithstanding the protections our client, Ms. Chulota, is entitled to in terms of the law of the United States of America, despite her status as a foreign national, we remind you that you and your office's obligations in terms of the Constitution have extraterritorial application to the extent that the life and or liberty of our client may be at stake. So there's a saying that she's protected by law in terms of the Constitution, even though she's in America. You agree?
I agree.
9. In consequence of the aforesaid, request you to urgently reply to our letter dated 17 October 2020 as regards Ms. Chulota. So there's a request asking whether there was this investigation, whether the visit had happened at the request of the South African authorities that had remained unanswered, and yet they're asking for an answer. You see that?
Yes.
10. Regarding our other client, Mr. Makashule, we note that your letter gives our client little comfort. It may respectfully be described as total avoidance of engagement. Then it's about Mr. Makashule in paragraph 11, but in 12 they say, As a public functionary exercising potentially invasive powers as regards our client, you are held to the highest standards of legality, including taking responsibility for what clearly appears to be an orchestrated trial by media currently being conducted against our client. So the allegation there, and also to you, is that they were contending that that your office and the DPC and the NPA had leaked these visits to the media. Do you have any comment?
No such thing, according to me, happened.
And I'm handed the letter that I was just given in court now. It's an email from Mr. The Nation on the 18th of November 2020. I will make the copies. Where it's under tab PQ, I beg your pardon. And yes, this is the email that was referred to. And he refers in the penultimate, no, I beg not penultimate, in the 5th paragraph to this visit, and he says to Ms. Charlotte, pertaining to your safety, and this has been read out in court before, pertaining to your safety, you're of the view that you're not in any danger. The assistance of the FBI was requested for the plain and simple reason to locate you and inquire from you whether you will cooperate with the SA police in prosecution. This they did, and I was pleased to note that you had, and I believe still has, a positive attitude and that you will cooperate with us, which we appreciate. The involvement of the FBI must therefore in no way be seen as negative towards you or your safety, but rather the contrary. So you agree that you were aware of this, it's here in the emails, and they didn't verify her address. They also inquired of her whether she would cooperate with the South African authorities. You agree?
I do.
And it's clear that Mr. Donation was aware of it, and that what's recorded here is accurate.
Yes.
Okay, so now we've established as a fact that there was this MLA, and the FBI went to verify address and said, are you going to help? No further arrangements were made with her as far as anybody else is aware, even as per her own statement. Do you agree with me?
Yes, I do.
Back to the letter, we'll explain to you about the media, the trial by media, and then in 13, Mr. Nkwashu says, in the premises, we request your urgent assurances that Sub 1, neither you nor anyone in your office is communicating with members of the media regarding the potential arrest of our clients. And Sub 2, neither you nor your office will engage in such conduct described above, given the serious violation of dignity that this has and will result in, made worse by the ongoing anxiety these threats of imminent arrest have caused to our clients. So you're aware of the media, that the stories that were breaking at the time of the impending arrest of Mr. Magashule. Do you agree with me?
Yes, I am aware of that.
And 14, although it may be unusual to ask you in your office for these assurances, is with respect justified, where on one hand people with apparent knowledge of your and your office's intention to arrest our client are leaking information to the media off the record, only to subsequently deny the veracity of such on the record when asked to comment on same. So it was stated in the media that they had obtained information off the record or from sources this was about to break. You agree?
Yes.
15. This practice, to the extent that it exists, is prejudicial to our clients, including the constitutional presumption of his innocence until proven otherwise. A trial by media is clearly not in our client or client's interests nor yours. You'd agree that it shouldn't happen through the media.
I agree with that.
16. A consequent media spectacle and arrests are being effected by your office only serves to undermine the perception that your office is conducting itself independently, freely and fairly. The statement is not likely made. So they're saying, don't make a spectacle and give the people the decorum they deserve. You agree with it?
I do.
17. We have no intention to speculate regarding your or your office's political agenda. Indeed, it is our and our client's belief that you and the office are conducting yourselves according to the highest legal and ethical standards. So they're saying we're not quite certain of a political agenda, but we would accept that you're acting within the highest legal and ethical standards. And you would agree with it?
Yes, I do.
18. But as dealt with in our letters, both we and our clients cannot take comfort when these matters appear in the media in the way that they are. This cannot continue. Agreed?
Yes, I do.
And now it comes to the issue that we're dealing with more frequently. Why? In paragraph 19. While it appears that you have no intention to inform your officers regarding your intention to arrest our client, alleging on the basis that we do not disclose information regarding the identity of suspects in ongoing investigations. We once again reiterate our client's intention to cooperate with you. So there was information of an impending arrest, and then expressed a desire to cooperate. You agree with me?
I see that, yes, and I agree.
20, our clients, in the plural, and ourselves are fully appreciative of your focus, remaining accountability, including doing your work scrupulously. We're just reminding the investigating prosecuting authorities of their obligations. You agree?
Yes, I do.
21. To that end, we reiterate that our officers are able and willing to assist you and your officers to ensure our clients hand themselves over to authorities provided there is a lawful request for same. Now, the important aspect of that, Captain Qualits, is that Mr. Nkwasha made it clear that he was acting both for Ms. Chilotto and Mr. Makashule, and they anticipated that the two of them might very well be arrested as suspects. It's clear from there. Do you agree with me?
I agree.
And then the 22 and 24 is just an undertaking to cooperate and ensure that there's compliance with any lawful demands. Agreed?
Yes.
And there's an underlining of the word lawful. So what I want to put to you is that it was clear by everybody's account that Mr. Nkwashu acted for both Mr. Makashule and Ms. Chilotto and represented them in their capacity as possible or potential accused persons, and you are fully aware of that. Do you agree with me?
Yes, I was.
Now that was followed by a response, a very short response from Mr. Donation sometime later. It's on the 9th of November 2020, and Mr. Donation sends a letter back in which he says, Maria Machuvana from the NPA, I beg your pardon, the NDPP, sends a letter saying, it refers to the letter and says they got nothing to add to the previous correspondence which is attached here with. And I'm going to show you this letter, and it's a letter that is signed by an advocate Cronier. My Lord, it will be my intention to mark these exhibits 12.1 continue, because it's a string of communication. It will all be under, with your Lordship's permission, under Exhibit 12, and I'll put them in chronological order, if that would suit your Lordship.
Yes, I was just wondering where we are at the moment with the exhibits.
Well, my Lord,
The last one
was AA1, which would be Exhibit 12, and this would be 13, I think it was. And then you'll have 13.1, and this in turn will be 13.2.
is Exhibit 12.
That email, my Lord, the one-page email by Ms. Chilotto, where she asks for the information. It was AA1. I can hand a copy to your Lordship.
This is Exhibit 12.
That would be 12, my Lord, AA1. In this series that we're dealing with now, the first letter.
Where is AA1?
May I hand it to your Lordship?
In the bundle.
It's not, my Lord. That's why I added it.
I see.
It would fall on top of the emails that have been referred to in two places, my Lord. But it wasn't previously in the bundle, my Lord, as far as I could work it out. I did.
Do you have an exhibit?
My Lord, if I may just have a look at the particular email.
There's a suggestion, my Lord, that it could be filed under PQ, which I think would make sense, because that's where the duplicate of those emails does appear. So then we can deal with these as 12.1 and onwards. I think it would make more sense.
What is the next one then after 12?
My Lord, we'd have, if AA1 goes under PQ, then it won't take up 12, then we'll have, this is 12.1, 12.2, 12.3 and following. Unless your Lordship wants to make AA1 12, and then we'll make this as 13.1, 13.2, 13.3.
Lord, if I may give some assistance, indeed, it is not, the follow-up emails are contained in PQ, so at current, AA1 is not forming part of PQ. And perhaps to not have confusion,
As your Lord,
is 13.
I'm in agreement. My Lord, if we can make AA1 that I handed to your Lordship at Exhibit 12, and then this correspondence here, my Lord, would start from 13.1, being the first letter that we handed up, and this will be the second one now, 13.2, my Lord. They flow in the sequence.
So AA1, which is in PQ.
No, it's not in
It's
PQ.
not, okay, but the AA1 then becomes Exhibit 12.
That's your Lordship.
Yes, and then the letter from
Mr. Nkoshu on 25 October 2020 will be 13.1 million.
yes, it is this one. I
The first one,
I see that.
No, that will be 13.2 million.
Okay. So where is 13.1?
13.1 was the first letter, my Lord. It looks like that. I can hand it to you, Lordship.
Is there no way that we can perhaps get all these documents that now deal with the trial within the trial under some tab in this Exhibit 9 in the big bundle, perhaps under PQ?
My Lord, we can look at that. I'm not sure with regards to these emails, as we had already had the Constitutional Court order that was submitted by Council for Mr. Lota being X1. So I don't know, perhaps if we can then follow suit and all the rest then being X2, X3.
I think let us keep it then as it is now.
As a court is
Just to avoid any further confusion. But I'm with you. Thank you, Mr.
Thank you.
Notice.
Right, so if we look at this letter, it's a letter in response to what we now have as 13.1. And it's a letter from the RD, the Investigating Director of Corruption, addressed to Mr. Makashura, where they speak of it's a response to the letter of 7 October 2020, and explain what the purpose of the RD is. Paragraph 2. In the third paragraph, they say, regarding information received that a warrant for the rest of your client was issued, you can only state that as a matter of course, we do not disclose information regarding the identity of suspects in ongoing investigations. Once an accused person has been brought before court, their identity and the charge or charges against them become a matter of public record. In this context, we believe that prudence to refrain from responding to rumour and speculation, our focus on accountability, and that includes doing our work scrupulously. You will no doubt advise your client of his options should he believe his rights have been violated. So they don't take issue with anything that's stated in Mr. Nkwashu's letter pertaining to the FBI and what they had done. Do you agree with me?
I do.
Give me a moment, Mr. Otis, please.
Thank you, my lord. I need to find my papers.
This letter that you dealt with at length of Kwasi, that is the one where certain allegations are made, just to sum it up, in respect of Ms. Shawota and the conduct of the FBI and so forth. That letter, this one, you can see that part.
Yes, my lord.
That is one we should now mark.
13.1, my lord. I've given you two. That's what's causing the confusion, my lord. I thought you'd misplaced yours.
Yes. No, it is already marked 13.1.
Yes, your lordship.
I do have it, so you can add this one, just take it back. Because I have two of them. So I have this 13.1, and then you are referring, I also have a 13.2. And you have referred to this letter addressed to Mr. Nkwashu. Your letter dated 7 October 2020. Is that the last one that you got?
Yes, ma'am.
That is 13.2. Fine, thank you.
Now, the next letter that I have, Captain, that I want to show you, that I need to contextualize it, is 23rd of November 2020. So it was after Mr. Makashula's bail application. It had previously been referred to in the previous matter as ESM 11, that I've made copies for my learned friends and for His Lordship and yourself, which I would leave to hand to you. It will be 13.3. And you'll see that this is highly relevant to what we're dealing with now. So it's a letter from Mr. Nkwashu on 23 November 2020. That's 10 days after the bail application. Addressed to the Director of Public Prosecutions at the Kasamaru and the NPA in Pretoria, Advocates Familiar Victoria. And it says, Henry State versus Elias Sekobela Makashule, Bloemfontein Magistrate Court. 1. As you're aware, we represent Mr. Elias Sekobela Makashule, our client. This letter is addressed to you on his instructions. 2. Our client and we have at sight of an article in the City Press that alleged that our erstwhile client, Ms. Marodi Chaloto, whom your advocate, Jay Donation, had informed the court and us as a state witness, had claimed to be unaware that she had become a state witness. Now you know that that's accurate from the emails that we have in the PQ. You know that?
Yes.
3. The article further refers to quotes that are alleged to be contained in an exchange of emails emanating inter alia from Ms. Marodi Chaloto. 4. It is a matter of record that we represented Ms. Marodi Chaloto when she was required to appear before the judicial inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state. That's what I told you previously. Mr. Nkwashu had acted for at the State Capture Commission. You agree?
I agree.
And you are aware of that?
Yes.
5. Additionally, as required in terms of the rules of that commission, we compiled an affidavit on Ms. Marodi Chaloto's behalf She duly took an oath and signed the affidavit before a commission of oaths on 5 December 2019. That's the affidavit that's in the Exhibit 9 that was signed by her before the commission that you have in the docket as well. Do you agree with me?
I agree.
6. In that affidavit, Ms. Marodi Cholote expressly recorded under oath that despite Mr. Dukwane's assertion to the contrary, she had not been involved in liaison in relation to what he had referred to as the asbestos eradication audit. That's consistent with what she told you. She had no direct knowledge of what had happened in relation to the asbestos audit, the subject matter of this trial, not trial within the trial. Do you agree?
Yes.
7. In the circumstance, it was clear that Ms. Marodi Cholote had consulted with our client and us, and had provided us with her version of the issues that subsequently became part of the subject matter of the draft charge sheet in the envisaged criminal prosecution of our client. Consequently, there can be no doubt that she was a defense witness. Do you agree with that?
Well, I see it's here, yeah.
Well, let's break it down, Captain. She sat with her attorney, Mr. Nkwashu, at the request of the State Capture Commission investigators, compiled a statement with his assistance that was exculpatory of both herself and Mr. Makashule, and deposed to it under the guidance and as a client of Mr. Nkwashu. Do you agree?
Yes, I agree.
And that, in effect, would make her a defense witness. In other words, a person says, these are the allegations, this is my version, I and this man haven't done anything wrong, that's my statement. She's a defense witness, you agree with me?
I would say she's a witness. I can't say defense witness or a statement. She's a witness in the allegations.
Well, let's break that down because it's rather important. To be a state witness, you'd have to attribute criminal conduct to somebody, do you agree with me?
Yes, I do.
She didn't in that statement, do you agree with me?
Yes.
That makes her a defense witness. I'll go, before I even jump to the conclusion, let's break it down further. If she gave a statement that's exculpatory of Mr. Makashule, she's his witness saying he did nothing wrong. Do you agree?
Yes, I agree.
That's what that statement did. Do you agree?
I agree.
That made her a defense witness. 8. Despite the above detailed events during October 2020, we were informed that Ms. Marodi Cholote had been visited by the Federal Bureau of Investigations in the United States of America, where she was studying at the request of your officers. We then addressed a letter to you on 17 October 2020. The letters that we've referred to, where you acknowledged that the FBI was sent to her address.
Yes, I agree.
9. The issues raised in that letter were not responded to in any meaningful manner. This resulted in us addressing a further letter to you on 24 October 2020. To date, that letter has not been responded to in any meaningful manner. He's complaining that he hadn't received adequate responses. You agree?
Yes.
10. Instead, we were notified that a warrant had been issued for the rest of our client. We then assured you that our client would cooperate in his matter of record, that he has done so. That's Mr. Makashule, and you were the investigating officer. You can confirm the cooperation and that everything was done by agreement in the bail application, other than the quantum of the bail.
Yes, I do.
11. At our client's bail application on 13 November 2020, we were informed for the first time in open court that Ms. Marodi Cholote was a state witness. In fact, it was a condition of our client's release on bail that he was not entitled to communicate with her. You can confirm you were there and saw that, is that correct?
I was, yes.
In fact, for all intents and purposes, it was at that stage the only statement that you These reasons you agree. And that's why this is accurate. Somehow it got to the press, as you'll see. 14. We find it reprehensible that you were not forthright with us at that time when in fact you knew that she was represented by our office and was clearly identifiable as a defense witness. You see the complaint there is that it's reprehensible knowing she's a defense witness. You don't talk to her attorney, you go directly to her and tell her she's a state witness, which we believe is improper. Can you question that?
Well, I don't have an opinion.
15. By virtue of Advocate the Nation having informed the court that the matter is trial ready, save for the rest of 2 outstanding suspects, we request you to provide us with a copy of the A, B and C sections of the police docket to enable our client and us to prepare for trial in this matter. You know that was subsequently provided, but B and C was off the court, a threatened court case that was involved. Yes, to confirm that. 16. Our client and we find it unconscionable that the media has access to information relating to this case prior to the contents of the docket being disclosed to the defense. You'd agree that's wrong, that the media can publish the contents of your docket before it's even disclosed to the defense.
No, it's not correct.
Thank you. 17. In the premises, we respectfully request that you urgently make available to us a copy of the entire contents of the docket as well as the indictment, so that we can ensure that our client's constitutional and pretrial rights are respected. That's normal to give an indictment in the docket. 18. All of our clients' rights, including but not limited to the right to argue at the trial in this matter, that a stratagem was adopted to intimidate Ms. Morodi Chilota with the object of procuring a retraction of a previous affidavit or expressly reserved. You see that? The very issue that this court is dealing with, you agree with me? Yes. There it is summarized as far back as 23 November 2020. You agree with me? 19. We formally record that our client will comply with his bail conditions and not communicate with Ms. Morodi Chilota, but it is a trite principle of our common law and has been recognized by the Supreme Court of Appeal that the freedom of witnesses from interference, whatever side they may take, is a keystone in the temple of justice. It's a quote from the decision of State versus M that I read before this honourable court. You agree with me? Right. 20. We eagerly await an acknowledgement of receipt of this letter and a meaningful response to issues raised herein. And then you'll see, sir, that the City Press article that's referred to is attached. Former personal assistant, a key witness between the Hawks, Morodi Chilota, where she says she was surprised to learn through the media after Mahashuda's first court appearance just over a week ago that she had turned state witness against her former boss. You've seen those emails?
No, I've seen them.
And there's a quote there I learned today.
Just a moment. Captain,
My Lord.
You are now here referred to many things that appear in this newspaper
Article.
I'm just wondering, can you keep up, or do you want to read this letter at your own leisure?
Well,
Not letter, the article.
The article. I'm aware of this, my lord. As I said, it was a while back. It's 2020. I can't recall all the exact facts, but I'm aware of the fact of the things that appeared in the media. That was said, and I know it was a huge issue during that period. But to go into detail exactly what was said, that I cannot recall. That I have to read. It depends.
I'm only asking you
Yeah.
because I want to give you the opportunity
Thank
to
you.
read through this article if you want.
Thank you.
If you say to me, no, it's not necessary, counsel can go on asking you questions about the article, then it's also okay with me.
I appreciate it, my lord. I would, if I may, it depends on what Advocate Horace will refer to in the article, if I may say that. Then I can see whether I can answer him or not. I do not know where he's going with the article. I know.
No, Captain, I think it's fair enough, and as His Lordship has said, take 5 minutes to read the article, and if you can confirm that that's the article that you had read previously, and what it said at the time, then it will save a lot of court time.
I will do that.
I don't think we all have to sit here watching.
remembers it. Yes. The important aspect of the captain, as far as I'm concerned, or if you turn to the second page, in Charlotte's letter to the Hawks, it says the record showed that Charlotte is currently based in the US, confronted the Provincial Hawks office last Friday at about 3 p.m. Just hours after the court granted the former Free State Premier bail of 200,000 rand and warned him not to interfere with witnesses. It says, Charlotte wrote, I learned today through the media that I'm a state witness, which came as a surprise to me. Kindly favour me with a copy of my affidavit which I've signed, confirming I'm a state witness. So conclude by saying that a speedy response would be highly appreciated. That accords with the emails that you've seen in this matter. Do you agree?
I agree.
On the next page, you'll see there that it refers to have been told by then Brigadier now General Gerber that should be called as a state witness, and there's a quote above the photograph. I'm sure that by now you've been informed of the arrest of Mr. Magashule. You are hereby informed that you will be called as a state witness in a criminal trial. As such, you are not to be in contact with Mr. Magashule or his attorneys. You are also not to be approached by Mr. Magashule or his attorneys, set as a bail condition directly or indirectly, said Gerber in his letter. That's consistent with the letter, you agree?
I fully agree, yes.
And beneath the photo you'll see, he warned Charlotte that failure to adhere to this may have serious implications. That should be contacted in due course. That's consistent with the correspondence that we have in court, you agree?
I agree.
And you'll see that the communication from Gerber was followed by a letter from Advocate Johan de Nation, the senior prosecutor in the Office of the Director of Public Prosecutions of the Free State, and it's quoted, and it's quoted accurately. Do you agree?
I agree.
And then it continues, the FBI visit, that's after reference to the emails that the journalists clearly had in their possession. Do you agree with me?
Yes, I do.
And then it continues, the FBI visit. City Press previously reported that Charlotte had been contacted by the FBI in respect of matters being investigated in South Africa, giving further confirmation that law enforcement agencies were building a case against Magashule. That's their perception of the visit by the FBI. Do you agree with me?
Yes, I do.
It says, Victor Kwashu Attorneys Inc. wrote in the letter to the head of the Investigative Directorate, Advocate Hermione Cronier, on October 24th, that Charlotte was a student in the US and she was particularly apprehensive to be visited by law enforcement authorities of that country, purportedly or ostensibly on your instructions or request. That's directly from what we have here as Exhibit 12.1. You agree with me?
I do.
So you confirm that that's that is what appeared in the press at the time.
I do confirm.
Now, Advocate the Nation copied you in his response to that letter that I'm going to hand to you now on the 8th, sometime later, being Friday the 8th of January 2021. This would then become 13.3 if I recall.
Now the one you're dealing, yeah.
It was ESM 12 in the interlocutory application. You see that it's from Johannes and the Nation with his email address addressed on Friday, January 8th, 2021 at 1:34 p.m. to Victor Kwashu, copying in the DPP, Advocate Somaru, and yourself. The subject, State versus Elias Ekobela Magashule, Bloemfontein Magistrates Court, and it says, good afternoon, Victor. I shall address the queries and concerns of your clients as follows. Paragraphs 2 to 6 of the letter, I do not intend to comment on neither the workings of the SEC nor evidence adduced here at this stage. Paragraph 7, this is the important one for this inquiry now. The fact that you represented Ms. Charlotte at the SCC does not automatically elevate her to the status of a defense witness. In any event, the question must be asked. A defense witness in whose case? Your other and current client at the time had not been charged in criminal court yet. As a matter of fact, he was not even subpoenaed to testify before the SCC. So what he's saying there, in effect, is that he didn't regard Ms. Charlotte as a defense witness because Mr. Magashule had not yet been charged. Do you understand it the way that I'm putting it to you?
That is what it says, yes.
And that's his opinion, as you always say. That's what appears to be his opinion. You agree?
Yes.
Then you'll see, it says paragraph 8, the visit by FBR was arranged by the investigators and I'm not privy to the details of their request. So he confirms that you and or Brigadier Gerber had arranged for the FBR to go there. And he says in paragraph 11, I confirm this. And then 13 to 14, discussion between myself and the witness is privileged and will not be disclosed. This office did not know that Mr. Lotto is represented by the SEC. We only learned this after receiving the letter indicating that you're acting for both Mr. Lotto and Mr. Makashule. So he's giving a time to it. You agree with that? He's saying that he was unaware, despite the letters and the public appearances, that Mr. Nkwashu had represented Mr. Lotto at the State Capture Commission. Do you see that?
I see that.
Paragraphs 15 and 17, the contents of the docket will be disclosed once all the accused had been arrested. The matter transferred to the High Court, only the A section of the docket will be disclosed. That's what I put you, the BNC was after a threatened and involved court application. You confirm that?
I do.
Paragraph 16, the prosecution is similarly aggrieved by the situation and found it unacceptable. Apart from formal media statements by the spokesperson of the MPA, no one else from this office discusses any aspect of the case with the media as far as I know. Cases must be adjudicated in courts, not in the media. So they agree that it was wrong by whomever did so to have leaked those emails to the media. And you agree with that?
Yes.
Paragraph 18, the suggestion or implied allegation that Mr. Lotto was intimidated by the prosecution and the investigators is rejected, and he signs off. So he rejects the allegation of intimidation that had been made at that stage. You agree with that? It's a matter of fact that, and it was in the interlocutory application that there was mutual legal assistance who confirmed that. Is that correct?
That's good.
Right, and in the mutual legal assistance, did you ever disclose, or in the extradition, did you ever disclose that Ms. Charlotte had been represented by the same attorney as Mr. Makashule?
For the extradition itself, that I can't comment, but the MLA, I have to see it to make sure. It was also done quite a while back.
Now, I'm going to challenge you and say to you there's no such disclosure. Do you have any comment?
If you say so,
Accept.
I accept.
And I want to put you that there was a failure to disclose that both in the extradition application and in the mutual legal assistance. You say you have no knowledge of what was disclosed in the extradition. You yourself never disclosed it, but in the MLA, you accept that what I'm putting to you.
Yes, if you put it to place.
The next thing that happened is there was an article that you remember. This was ESM 17 in the interlocutory application, and we're moving forward now to 16 August 2021. And it was ESM 17. I'm going to hand you a copy of this article. It was in the Daily News on 16 August 2020. It's only one page. It will be 13.5, my lord. And you'll see it deals with the assistance by the FBI in what's referred to as the prosecution of Makashule. Have you seen this article before? It's a short article, I can take you through it.
Yes, no, I can't say that I have.
It says the Hawk sought the help of the FBI recently to obtain evidence to use against ANC Secretary General Ace Makashule, who appeared in court last week on charges of fraud, corruption and money laundering. 7 months ago, the NPA told the court that Makashule's US-based former personal assistant, Moroni Chilota, was a key state witness, but she has yet to make a statement implicating Makashule in wrongdoing, notes City Press. That's accurate, you agree with me?
Yes, I do.
Hawks investigators in the request for mutual legal assistance from the US Attorney General said Chilota's statement was essential to pinning down Makashule. You've seen the mutual legal assistance were involved in that, and you agree that that was stated as quoted there. It's also consistent with your affidavit in the Constitutional Court. Do you agree with me?
Yes, I do.
She was ahead of the suspended Secretary General's appearance in the Free State High Court, Bloemfontein, last week. The Hawks wrote to the FBI requesting permission for the investigation team to attend the interview.
Lord, if I may at this juncture, if I may ask for the relevance of this, where is this taking with regards to jurisdiction, these newspaper articles? There are many allegations going out as to how it had come to the newspaper's attention. However, this has got no relevance and bearing on the actual reason why we are here, being the jurisdiction. With all due respect, my Lord.
Yes, I hear what you say.
My Lord, we say it's directly relevant because this was provided. You'll see the heading there, my Lord, ESM 17. And you'll see there, my Lord, that it touches on quotes from the investigators from the Commission, and it touches on, and this witness is already, I know my other friend was a bit slow to jump up, it already conceded that it refers to Lotta's statement being essential to pinning down Magashule, which is the very issue that we're dealing with here, my Lord, and that she was coerced to implicate him when her statement had not done so initially. That's why I said it's directly relevant with respect.
Yes, you say, if I understand you correctly, this new paper report is relevant in the sense that you say that accused number 17 was only used, if I can use the word used, to provide evidence which could implicate accused number 13.
And that's why they first thought she was cooperating, and when she refused to do so, they intimidated her.
Yes, but and so you say there was a measure of intimidation as far as accused 17 is concerned.
Additionally, my Lord, if one has regard to this article, it provides additional information in ascertaining where the source of information to the media was, because there are things in this article, my Lord, that were not known to the defense, could not have been known to the defense, that will indicate beyond any doubt, my Lord, that the leak was from within the prosecution and or the investigation teams, because it refers to meetings that took place that the accused persons would not know anything about. It's directly relevant with respect. It flows with the correspondence that flows after that.
Yes, I think Ms. McPherson is concerned about the fact that in a certain sense we are now moving dangerously close to the merits of the case against Mr. Magashule himself, and that is not what this trial within a trial is about. Am I correct?
Indeed, so thank you, my Lord.
Is there some way that you can try and confine your questions to this witness as far as this article is concerned to accused number 17 and whether she's been extradited lawfully?
Yes, my Lord.
Please. Will this be exhibit
13.5, my Lord.
13.5? Yes, I agree with you.
Okay. Now, if you see this article, Captain, there's reference here, and that was the point that I wanted to get to, that there was a meeting in South Africa between the FBI and the investigating authorities. Do you agree with it?
Yes, I do.
You attended that meeting. Do you agree?
I do.
Right. So it's not only a case of having sent a request for mutual legal assistance and having requested the FBI to go and look where she is and fetch her for the interview. Subsequent to that, there was a meeting in South Africa that the FBI attended in the Free State in relation to this matter. Do you agree with me?
I do.
And that's referred to there. And I want to put to you, Captain, that That had to have been leaked by somebody from the prosecution or investigative team because the defense had no knowledge of that. Do you have any comment?
Well, all I can say, it was definitely not me.
The leak wasn't you, but you attended that meeting.
Yeah, I did attend the meeting, yes.
And nobody from the defense side was present at that meeting.
No agreement.
Where do you...
My Lord, if you look in the middle of the page, I will read it aloud. City Press says it has learned that the FBI was long involved in the investigation, including participating in a 4-day meeting in February attended by the Hawks, the SIU, and even an investigator from the Judicial Commission of Inquiry into allegations of state capture, despite the NP in court last week distancing itself from collaborating with investigators from the Commission.
Yes, I see that paragraph.
The captain has confirmed that he was at that meeting. And I want to ask you, Captain, do you also confirm that it was attended by members of the Hawks, SIU, and an investigator from the Judicial Commission of Inquiry?
No, I can't confirm that. I know we were there. We were working with them. I cannot confirm SIU or state capture. They had no interest in. I can't think state capture will be there because they had no interest with them.
I can't argue on that. If you look at where they quote accused number 13, Machashuli here, and it's directly in point. They say here, beneath that paragraph, Machashuli leveled serious accusations against the NPA last week, including a claim that the state was colluding with the FBI to get an adverse statement against him from Chilota. And there's a quote there. My fear is that they may even threaten and force Chilota to write a false statement, but because I know I haven't done anything, I'm not worried whether Chilota is a state witness or not, because there is no cent I've taken from the government. In criminal law, there is no such thing as an oversight or failure, he said. So the point is that even at that stage, on the 16th of August 2021, Mr. Makashula made it clear that he was under the impression that the investigative authorities would intimidate and threaten Mr. Chilota to make a false statement to incriminate him. You see that?
I see what this reporter wrote, yes, but it's a news article.
Yeah. No, I'll take it no further than that, but that's the quote that's there, and I wouldn't be entitled to take it further. I don't want to abuse the position. But what then happened, Captain, is there was a letter by Mr. Nkwashu on the 19th of August 2021. In other words, 3 days after this, which will then be 13.6. I believe to hand it to you. That will bring it, make it more current. And you'll see that it's a letter on 19 August 2021 addressed to Advocate the Nation by Mr. Nkwashu, referring to this matter, and Mr. Makashula being accused number 13, and that there had been an argument in court relating to the pre-trial case management meeting on 11 August 2021. And in paragraph 3, Mr. Nkwashu says, our client has instructed us to record his displeasure with the way in which this matter has thus far been handled by the prosecution. We have further been instructed that our clients have view that we will not receive a fair trial, and as the issues raised herein below are addressed as a matter of urgency before the next pre-trial case management meeting that has been scheduled to take place on 19 October 2021. Then there's reference to a news article that refers to some of the information contained in information disclosed and supplied to them by the investigating team. He then asks for the prosecution to provide, and these are the sub-paragraphs. Firstly, a copy of the minutes of the meeting in Clarence for those 4 days, 8 to 12 February 2021. Secondly, an audio recording. Thirdly, any responses to the mutual legal assistance. And a copy, in 5.3 it says copies of all and any responses that might have been received by the prosecution and or investigating authorities to the request for mutual legal assistance that were sent to the US government ostensibly for the interviewing and obtaining of a witness statement of Ms. Moradi Chilota, our client's former personal assistant, was also historically a client of ours and a defense witness. And so he identifies her as that. You see that there. And then he asks for other details which aren't the subject matter of this inquiry. But there he made it clear that Ms. Chilota had historically been his client and the defense witness. Do you agree with me? In 5.3.
Yes, that is what it says.
Okay. Now, Mr. Donation responded to this. This will be 13.7. You'll see for the record it was ESN 19 in the he refers to it's from Advocate Donation on Friday the 20th of August 2021, addressed to Mr. Kwashu and copying in Advocate Samaru, referring to the letter of 19 August, the day before. He says, "Good morning, receipt of your letter is acknowledged and I respond as follows." One, paragraph 2. The prosecution does not speak to the press except where formal statements are made by the official spokesperson of the NPA. The view of the NPA has been outlined to City Press as quoting an article, and this is still the position. The interesting question is, since the prosecution did not supply information to City Press, who did? It further needs to be noted that not all the information in the article is factually correct. You see that?
Yes, we do.
Right. 2, paragraph 5.1, there are no minutes available. And even if there were such minutes, the prosecution would not have disclosed it. 2, no such recording exists. 3, correspondence between the US and the prosecution pertaining to the request for mutual legal assistance, MLA, will not be disclosed. And then the rest doesn't pertain to this. So he says, there was a meeting, and we didn't keep minutes. Even if we did have, we wouldn't give them to you. What's reported in the article might have come from somebody else, not from the prosecuting authorities. Could have been the investigator if he doesn't commit himself, but he says it's not factually correct in certain instances. You agree with that?
Yes.
You'll be pleased to know that I only have 2 more articles that I wish to refer to. And that will then complete this series of 13 documents. The first one is an article that appeared in the City Press on the 3rd of October. It is ESM 20. In the previous matter, it will be 13.8. It looks longer than it is. There's just commentary. We only copied the entire document so that you couldn't be accused of leaving anything out. The actual article is much shorter than it appears to be the case, and I'll get to the relevant parts as quickly as possible. Now, I have no doubt that you've seen this article, but it's up to you to confirm that you have. You'll see on the second page, and it's directly in point to what this court is hearing a trial on today. And it says the Hawks and FBI investigators allegedly used tough questioning methods in the interview of the star witness in the fraud, corruption, money laundering case against suspended ANC Secretary General Ace Makashule. Moradi Chilota was Makashule's personal assistant when he was Premier of the Free State. Finally spoke to law enforcement authorities last week, and they spent at least 3 days taking evidence in Washington, the US. We know that's not accurate because there are only 2 meetings, and I don't think there can be any doubt about that being on the 22nd and 23rd of September, respectively. It says one of the sessions was held at the Sheraton Hotel in Washington, D.C. Then you'll see if you turn the page in dark, it's written 399, that's from the civil interlocutory. It says that he is accused of requesting financial assistance for students from companies that benefited from the asbestos contract and those that supplied goods and services to the provincial government. That's the allegation that you wanted Ms. Chilotta to make, do you agree with me, or to confirm? It says Chilotta solicited the donations and she told the Zondo Commission in December 2019 that she used her own discretion regarding who to approach for assistance. According to the state prosecutors, the donations were requested at the behest of Makashule. That's the very issue that you took issue with in the interview. Do you agree with me?
Yes.
So sources in the Free State this week said Chilotta spoke to the Hawks and the FBI investigators last Wednesday. The interviews continued until last Friday. We know it was only Wednesday and Thursday. Do you agree with me?
Yes.
And it says, an insider said apparently they threatened her to recant to her original account and to divulge more than what she knew, which is the substance of her allegation and was the subject of your cross-examination by my learned friend, former Chilotta. Do you agree with me?
I do.
It says, in fact, said the person has intimate knowledge about the matter. She has been pushed to confirm that every request for money that she made on behalf of the needy students was an instruction from Makashule would benefit somehow because the donors were doing business with the state. That's not accurate as per the transcript, but it comes very close to what was being put to her to identify a particular person. Do you agree with me?
I do.
It says she was pressed to give some version like that, but the problem is that she recanted her earlier testimony. That if she recanted her earlier testimony, she would be in contempt of court. Do you disagree with that?
I disagree with that.
And there's another quote. She already gave a statement and testified at the State Capture Commission of Inquiry. If she gives two versions undoubted, then it would put her straight into contempt. The source added that sympathizers suggest that she should talk to social media and speak out. She will speak out if she's under such heavy pressure, one said. If Chilotta made a new statement, if Chilotta did make a new statement, the state would have to provide the defense of a copy before the matter was brought back to court to help them prepare their case. So it seems like it's an interview that was held with somebody with legal knowledge pertaining to what had happened in the interviews. Do you agree with me?
It seems so, yes.
And you'll see, if you continue down, that there was issues about the provision of the docket, and then they say here, on the page that is on the top right-hand corner, 401, and I'm going to finish at 402. The person close to Makashule said there's a do-or-die case for the state, so they have to use coercion, and without Chilotta, the case falls apart. It's just desperation shows again that this case is political. And then it refers to the race against time. And then there's an issue about judges. But the point is that under the heading Ace Vice Judge says last name Chilotta was designated as a key witness by the court, even though she was yet to allege any wrongdoing against Makashule. And then there's a reference to the request for mutual legal assistance, and that her statement was essential to pinning down Makashule, the quote that I put you earlier. Do you agree?
Yes.
You were aware of this article, do you agree?
Yes. Yeah.
Well, what is the purpose of handing in this article, Mr. Harris? It's based on rumors and what insiders and outsiders said while we sit with the transcript of the interview.
And my Lord, on this one I do concede there's a lot of hearsay, and it's not identifiable to a particular person or source. So I wouldn't argue that one much further with respect, my Lord. I don't want to take up time on unnecessary things. But there is one further statement. It's also an article, my Lord. What I would request, my Lord, I see that it's past 15:30. Can I just have a look at these overnight, my Lord, with a view to possibly excluding them and cutting down on this cross-examination? And I can assure your Lordship that we will be done by tea tomorrow with every document and everything. I don't have any others under this, other than this last one that we consider under the 13th series.
This one that you are dealing with now,
Yes, ma'am.
that will be Exhibit 13.8.
Yes, ma'am. then I'll reconsider my view on 13 now. It had been used in the interlocutory, that I just need to peruse it carefully now.
Yes, the court will adjourn till 9:30 tomorrow morning.
Right. Yeah.